Yes, James.
My lady. Just to finish off the second of the points I wanted to make about impracticality and consequences and all of that. There was some suggestion by my learned friend, I think in discussion with my Lord Burrows, about whether one could control those consequences by reference to the word due before regard. In other words, you can pay due regard to something by not going into territory which would be dangerous from a foreign relations perspective, say. And we, with respect, are a bit nervous about that idea. The difficulty with it is, we submit, that you are here trying to test parliamentary intention against the basic idea of what 149 is designed to do. And if extraterritoriality, with all the transparency and so on that we were discussing before the short adjournment, would land one in trouble in relation to any of the examples we were discussing then we do submit it's very difficult to try and use the idea of, or the adjective before regard of due, as being the mechanism for avoiding the problem. And that is principally because due regard within the structure of 149 is pretty plainly dealing with the nature of the regard that is to be had. It isn't an excuse not transparently to address the issues, or not to address the issues at all. So if I wanted to collapse it into a proposition or a submission, due is designed to regulate sufficiency of regard. I'm sure it could be put better, but due is regulating sufficiency of regard. It's not regulating the basic subject matter to which regard must be had. So we're not sure that there's an escape route via that particular exit. I wanted to move on to the third point, if I may, which is a slightly separate point, about the difficulties of 149 applying in circumstances in which the substantive duties under the Act do not. So this, if you will, is the flip side of Mr. Jaffe's point the other way. One needs to recognise that the question of the territorial reach of 149 is a general one. But does it, or do its constituent parts, apply to require consideration of positions of those outside the United Kingdom, so long only as the decision in question is made by a public authority here? There is, or was, some controversy over the nature of the exception in 29.6, when read with 29.9, and I'll come back to that. But the point here is a more general one. 149 imposes duties in relation to functions, as you've seen, due regard in the exercise of functions, and save for the limited, and on any view limited, entry clearance exception in 29.9, the Court of Appeal were plainly right that none of the rest of 29 is extraterritorial. And they concluded as part of that analysis that function, the same word, in 29.6, public function, does not cover those outside for all the reasons that Lady Justice Simler gave in the earlier part of her judgment, including specifically the key paragraph for this purpose, which might be thought to be paragraph 58 of her judgment. But what that means is, if that conclusion is right, and as a basic proposition, it's unchallenged. There may be a debate around how far 29.9 extends and so on, but as a general proposition, it means that there will be large tracts of decision-making under Section 29, to take that as a mere example, where the substantive discrimination provisions will plainly not apply to the benefit of persons outside the United Kingdom. And yet, on my learned friend's case, the 149 duty would do so. And that plainly is not a coherent position. So the general point is that the fact that that functions in the UK is not good enough for 29.6 must equally mean, the same basic concept is used, that they're not good enough for 149. And that is no doubt why the Court of Appeal, Lady Justice Simler, said, as she said, in the final sentence of 101. she went out of her way when considering the 149 issue, to say at final sentence 101, the points made earlier, which suggest that Parliament did not intend Part 3 to have extraterritorial effects, save in limited circumstances, apply with equal force to this provision. And it's for that reason you are in effect, or would in effect be dragging over the general logic in relation to extraterritoriality from 29.6 to apply equally in the context of the similar wording of 149. So if the Court of Appeal was right about 29.6, that general logic must extend over to 149. So if the suggestion then is that 149 applies, but only, this would have to be the submission, that 149 applies only, my learned friend's submission that is, 149 applies only to situations in which the substantive duty applies, that must be by way of exception to the general rule, but for the reasons I've just given, 149 does not apply extraterritorially. But the difficulty with that submission is that there is nothing whatever in the language of 149 to suggest that. And it would be very, very odd indeed if that was the intention, but it wasn't expressed, not least because that would be a point. In other words, this 149 set of provisions applies extraterritorially, but only in circumstances where the substantive duties under the Act apply extraterritorially. That would be a position of some sophistication and provision and precision, which one would naturally expect need to be expressed and covered.
So is this your submission against Mr. Jaffe's section 149A point, or are you going to make a separate?
I'm going to come to 149A at the end. This is a more general point, which, as it were, looks through the other end of the telescope with this, and it says, here are some provisions which on any view of the substantive provision don't apply, brackets the whole of 29 and everything that it covers apart from 29.6 as expanded to 29.9. If that's right, then if 149 in its generally expressed terms is extraterritorial, then you end up with a complete incoherence the other way, if that makes sense. And if that's the starting point, which I respectfully submit it is, then what you have to do is to say, well, no, in order to escape from that incoherence, you have to posit a situation in which 149 applies, but only if the substantive duties themselves apply, so you get what my learned friend calls symmetry. And the difficulty with that is that if that's really the position, that is a position of, as I described it, of some sophistication and some precision in terms of the extraterritoriality and its limited extent in 149. And if that's really the position, then why on earth isn't it in 149? That's exactly the sort of thing you would expect to see expressed in 149. I do not, for good measure, accept that there would be incoherence the other way. I'll come back to this point. In other words, if the substantive provision is extraterritorial, 29.6 as expanded by 29.9 and so on, I don't accept that would be incoherent. Not least because, well, perhaps three short points at this stage in relation to that. Firstly, we submit that Lord Justice Underhill was plainly right to recognise that 149 is of an entirely different character to the substantive provisions, e.g. in section 29. That's 109, I think it is. That's 110. Let me just give you the right paragraph number for that. That's 112. I'm sorry, so sorry. It's the final sentence of his judgment. The duty under, he said, this conclusion, i.e. the conclusion supporting the idea that 149 isn't extraterritorial, the final 3 or 4 lines, that conclusion is not inconsistent with my view that 29.6 is extraterritorial scope in the circumstances of this case, that the duty under 149(1)b is entirely different in character from the substantive duty not to discriminate and so on. So that would be another reason why there isn't any incoherence. In any event, any difference in scope between the substantive provisions and the PSED is, even on the Court of Appeal's analysis, very limited, and the Court was careful to make clear that it was only in the application of the scheme rules to the facts of the substantive provisions, but the facts of the individual case that the substantive provisions were in any way engaged. So we do respectfully submit that that reasoning is correct. In any event, as we've argued in our written case, and I'm not proposing to develop this orally, we do submit that the Court of Appeal judgment on 29.6 and 29.9 was wrong for the reasons that we've set out in our case. But if that is right, of course, there is no incoherence. Make your own minds up about whether or not that is right or wrong on 29.6 and 29.9. So that's the third and discrete point, which, as I say, rather looks at incoherence and the relationship between the substantive provisions of one and through the other end of the telescope, and then asks the follow-up question, well, if you can escape from that by doing it in this way so that they have to marry up, why isn't that in 149?
Why, though, if the purpose of 149 is to improve decision-making, why would Parliament not want to improve decision-making when it's made in a limited context of extraterritorial functions, if it does in the exercise of UK-based functions?
Well, because that, it might be thought that expresses the purpose of it rather too generally, as it were. No doubt it is there in part to improve decision-making, but it's in part it's to improve decision-making in relation to the matters set out expressly in 149. So you can't avoid the idea that 149 requires you to look at and therefore to address all the things which it covers. Yeah, so, that. The fourth area I wanted to cover of the five is the object and purpose of the provision. And we submit that that points, or those features point strongly against extraterritoriality. As the Court of Appeal rightly held at paragraph 58, the legislative intention in enacting the Equalities Act was to legislate for its own citizens, the public, in the UK. And a key feature of testing Parliament's intention is to examine degrees of connection to the UK. Did Parliament intend, we're back to Lord Wilberforce, did Parliament intend that a person in the situation of the claimant would have sufficiently strong connections with the UK, because only sufficiently strong connections would do to create the imputed intention to confer that benefit on that person. And there's nothing in the legislative history that suggests that in enacting the Equalities Act, Parliament was intending to legislate to cover or to ripple out, as it were, the benefits of our system of thinking and democracy in those respects, to wash those out to the entire world, or to require our public authorities to take into account all of that breadth of matters in all of their decision-making. And put more narrowly, there's nothing to indicate that it intended the benefit of these provisions, as it were, to inure to those who had no connection with the UK whatever. And we've summarised that legislative history in our case at paragraphs 18 to 32. And the real focus from those legislative history documents was on a particular concern about local communities, that is, local communities in the UK. What then, fifthly and finally, before I come briefly to 1491A as a specific topic, what then of the other statutory provisions that may bear on this question? We submit that the prime point to take from those other statutory provisions is that if Parliament had intended to indicate that a provision should have extraterritorial effect, particularly one with the complications and issues that we've just been exploring as 149, then it would have done so in express terms. There are 2 points perhaps to make in that respect about section 29. Firstly, section 29.9, whatever its precise reach and effect, which may be controversial, but whatever its precise reach and effect, is, on any view, a specific, limited and express provision for limited extraterritorial effect. And absent that provision, as the Court of Appeal correctly found, Section 29 would not have had extraterritorial application. And the simple point is that there's nothing similar or remotely similar in Section 149, despite the fact that the issues of extraterritoriality that would need to be grappled with in legislative policy terms are, if anything, more complicated because of the breadth of application of it. But secondly, I've made the point, and I don't repeat, that large swathes of function under Section 29, brackets all except the Section 29(9) cutout, are, on any view again, not extraterritorial, and so you end up with the incoherence I identified as my third point. So those are the points I wanted to make about the other key relevant statutory provisions in relation to this. Coming directly and finally then to 1491A, I make three basic submissions about 1491A. Firstly, if the position is, as we respectfully submit, it very plainly is, that 1491B and C are not extraterritorial, then it would be very odd indeed if 1491A was. Very odd if they effectively meant different things in relation to something as fundamental as extraterritoriality without saying so. And again, if that is the position, again, it's a sophisticated and precise point. And all the more reason for expecting that Parliament would deal with that expressly if that subtlety truly was its intention in relation to 1491. In other words, to draw completely different extraterritoriality consequences as between those three elements of exactly the same subsection.
Well, I mean, why is that so? I mean, on the face of it, you've got very clear indication in, well, I realise you've got an argument against the position in relation to 29.6, but let's just assume that 29.6 is applicable and by reason of 26.9 it has extraterritorial effect. The exact same wording is then replicated in 1491A, discrimination, harassment, victimisation. In that sense, there's a tie-up. It looks as if one could see that as the procedural background to substantive duty. Why do you say that would seem odd to pick out just that one as opposed to other elements of 149?
Well, because, I mean, for the reasons I'm going through. Firstly, because you do create the odd situation in which something like extraterritoriality is not applying to 149B and C, but it is applying to A. Now, the question is whether the language leads you to that place. The second point I was going to make is, true it is, as my Lord points out, that discrimination, harassment and victimisation are concepts that are common to the substantive duties under the Act. But this is, in 1491A, a different obligation to 29.6 or anything like the substantive duties one has in individual cases. This is a much broader strategic duty, sort of duty, to eliminate discrimination and the need to eliminate discrimination and so on. So this is all about the strategic position. This isn't, as it were, a check on individual decision making to ensure that whether or not you're going to breach someone's rights not to be discriminated against or harassed or victimised is done properly. You don't need it for that purpose. Public law requires you to do that. It's not about that at all. This is about eliminating the strategic and general objective of eliminating. So it is, I respectfully submit, and the Court of Appeal Lord Justice Underhill was right to conclude that 1491 in general terms is very different. It's a different species of obligation to 29.6. So you've got the oddity that it applies to some parts of it but not others, and you can't get there, can't remove that oddity by saying, well, this is a provision of a very specific kind which is much more closely or directly linked to the substantive duties. It's a different duty in nature because of its because of the word principally, eliminate and all of the generality that imports. This is not just, as it were, an additional unnecessary public law and statutory form support for needing to think about these things. So those two points arise.
So you have a duty not to discriminate or to prevent discrimination, but there's no Section 29 duty to eliminate discrimination.
No. As a general strategic, what this is doing is to create a general strategic obligation at a much higher level. It's a different beast. My learned friend sought to get to a similar place to the place that my Lord Burrows was putting to me by saying, well, this is all very different. And again, it was his answer to my Lord Reed's question, why don't we have the same problem with masks and Chinese government behaviour? Why don't we have the same problem in relation to this? To which my learned friend says, no, well, this is all about the domestic thing. 1A is all about the domestic duties because of the words that is prohibited by or under this Act at the end of the section. So he says, well, there it is, there's the tie-in. It's the Lord Burrows, so there's the tie-in back to that, and you don't get that in B and C. But the difficulty with that is it is with respect to question begging, focusing on those words. It's not at all clear that those words are, in effect, able to cut out consideration of foreign jurisdictions' behaviour or all of the difficulties that were identified that arise in relation to B and C. And it's very far from clear that they could do anything like that, rather than being a description, or if you will, a flagging of what sort of conduct is covered by the general strategic duty to eliminate. So the purpose of those words is not, as it were, to tie one in to the domestic world. It is simply to identify, by reference to that phraseology that is prohibited by or under this Act, the nature of the conduct that is being made the subject of the duty to eliminate. And that isn't unusual, even within the structure of 1491, because one sees in 1491B, where that same point is not made by my learned friend, that that provision, and indeed C as well, is using concepts drawn from the Act to describe the nature and content of the duty. In those provisions, it's protected characteristics.
So you say there's no tie-up at all. Is that right? You go as far as to say that no tie-up at all between 29.6 and 1491A?
I say there are different duties. I say there's no necessary tie-up of the kind that my learned friend would need to make the point that says this can be split out from B and C, so as to lead to the conclusion that A is extraterritorial and B and C are not. And I draw on Lord Justice Underhill's correct conclusion that they're different beasts. I draw on the fact that the language at the end of 1A cannot be used for the purpose for which my learned friend sought to deploy it. It's much more likely to have been a description of the nature of the conduct which is the subject of the duty. And I draw particular force from the idea that it would be a very odd and sophisticated conclusion that the one IA was extraterritorial and the other two weren't. It might be thought that's all the more so, that point, because if one looks at the basic idea of what the duty in 141A is doing, it's about eliminating discrimination, true at a general and strategic level, but there isn't a million miles worth of difference between eliminate discrimination and advance equality of opportunity. Which again suggests that they're not dealing with kind of fundamentally different things, the one tied back into the domestic substantive individualised duties and the other not. That closeness, put the point positively, that closeness between the opening words of A and the opening words of B, and indeed to some extent the opening words of C, the closeness between them tends rather to suggest, we submit, that the same extraterritoriality principle and or rules and or approach should apply to all three of them. But I do say that by reference to any standard of sensible legislative drafting, in a piece of legislation where the draftsman has gone out of his way to draw very sophisticated extraterritoriality cutouts, if my learned friend is right and 1A does it and 1B does not, it's a mighty surprising thing that Parliament didn't legislate to that effect. I should say finally in relation to this point that the idea, if it was floated as such, that there would be in some way a gap in protection, it is not a good point, I respectfully submit. You don't need 1A in order to ensure proper consideration of the need not to discriminate or harass or victimise in individual cases. You don't need it because those are duties of substance and of result. You have to avoid discriminating, harassing or victimising full stop. Doesn't matter what you think you're doing. You actually have to avoid doing that. That's the nature of the substantive duty that is imposed. But even if there were some duty to think about that hard beforehand, that would be imported as a necessary matter that public law would import as a mandatory relevant consideration. But more importantly, and perhaps standing back a bit and looking more broadly at the suggestion there might be a gap in protection, you have those substantive duties. They provide the protection. It is no integral or necessary part of their proper enforcement that you should also have the elimination of discrimination and so on. So in other words, 149 in its entirety is not a necessary component in the proper protection that is afforded by the substantive provisions of the Act. So for all of those reasons, we reject the proposition that you can draw that distinction between the different subparts of 1491.
Because if it is, in fact, discriminatory conduct,
That's it.
they can show that they've thought about it and decided it wasn't.
Wouldn't matter.
It doesn't matter.
It wouldn't matter. I mean, to some extent, it's the kind of misbehaving logic. Well, my lady, those were my submissions. We've, through the diligence of others, not me, Benyon has been found. The relevant bit of Benyon has been found, and I'm hoping it's wending its weary electronic way towards you.
Just received it.
Maybe a counterblast from my learned friend, which relies on some other textbook.
Yes, we have.
Potter and Lowe as well.
You have them all, but
Thank you very much.
If I can just focus on Benyon. Benyon, I was, at least I was delighted to see the bit that I read over the shorter German. It looked as though it was consistent with at least what I was suggesting Lord Lloyd Jones might have been saying at the beginning of paragraph 21.
Yes. Yes.
But there it is for what it's worth. I'm sorry that wasn't in the bundle before. There was some Benyon in there, but it wasn't on this point.
Correct.
It was on explanatory notes.
Yes, indeed. Thank you very much.
Well, my lady, those are my submissions, unless I can assist further.
On your cross appeal, you just rely on
What we've done in writing. I'm not going to develop that already.
Thank you, Sir James.
Okay.
Mr. Jaffe.
Well, my lady, I'll deal with A first and then B, if I may. On A, we say there is a clear and express textual link between the public sector equality duty and the substantive. And the importance of that link has long been recognised in the case law under the public sector equality duty. And so the primary authority which draws that link is the decision of the Court of Appeal in Elias, which is the Japanese civilian internees case. Could I ask the Court to have a brief look at that? It's in Authorities Volume 1, Tab 6, and the relevant passage is in electronic, page 848. Lord Justice Mummery, dealing with the substantive equality issues, so not the public sector equality duty at this point. And in paragraph 133, the point that's being made by Lord Justice Mummery is that there was a breach of section 71, which was the predecessor to the public sector equality duty, and that added to the difficulties of the Secretary of State in substantively justifying the imposition of the birth link criteria. And the difficulty which the Secretary of State had is to justify something which he didn't even consider required any justification at the time, which is why there was a breach of Section 71. And that's pretty much the same thing as what Mrs. Justice Lane found had happened here. There simply was no attempt to think about these issues at the time, and that was therefore relevant to the question of substantive justification. So my submission is not simply that it's a one-way street, it's actually a two-way street. That compliance with the public sector equality duty feeds into substantive questions of justification under the Equality Act, and that's a well-established principle. All I also say in this case is it goes in the other direction as well, that if something is within the scope of A, and A specifically refers to compliance with the law, discrimination, harassment, victimisation under the Act, then the territorial scope is likely, we say, just as a matter of logical analysis, to be the same. Now, that point was then expanded on further by Lady Justice Elias in her concurring judgment at page 870, where she dealt at paragraph 273 and onwards with section 71 of the Race Relations Act. At 273, Lady Justice Arden points out in the third line that legal proceedings are not the only way of policing anti-discrimination legislation. Monitoring and self-assessment by public bodies also furthers the aims of such legislation. And again, that's the point which I've sought to develop, which is it requires the purpose of the duty is to require a degree of prior advanced thought and consideration to help avoid, amongst other things, substantive breaches. And then at paragraph 274, she says the purpose of section 71 is to require public bodies to give advance consideration to issues of race discrimination before making a policy decision. And then she explains the importance of that requirement for fulfilling the aims of the anti-discrimination legislation, and it's therefore an important matter. So that's just an example of the link, and the link in the authorities, we say, operating in both directions. And it is, we say, certainly a link which exists. My learned friend then says, well, there is no link, and reliance on cases such as Al-Skaney do not assist the appellant. But we say that the concept is the same as the issue in Al-Skaney, which is logically, is the intention of Parliament, or the intention of the legislation, to link between a substantive obligation, in Al-Skaney, a substantive right to make an individual petition to the Strasbourg court, and here, a substantive discrimination claim. We say, yes, the issue is the same. And if anything, this case is stronger than Al-Skaney, because of the reference to discrimination prohibited by the Act in section 1491A. And it's, in our submission, very important to remember that not all discrimination is prohibited by the Equality Act. The Equality Act is not some statement that in this country, or in the United Kingdom, all discrimination is prohibited. The scheme and structure of the Act is that, first of all, it defines the protected characteristics in the opening sections. It then goes on to define direct and indirect discrimination. And then it makes discrimination unlawful in certain specific spheres of national life. Employment is one, and public functions in section 29 is another. But not all discrimination is unlawful. And there are circumstances in which discrimination, even direct discrimination, is lawful. And so that's why those words in subsection A are very important, because they are linking back to the substantive limitations, of which there are many, in the legislation. The final point on subsection A is that I simply observe that the Secretary of State has not sought to develop at all, orally, the respondent's notice point. It hasn't been formally abandoned, but my learned friend has not sought in his oral submissions to criticise either the analysis of Lady Justice Simler and her textual analysis, or the alternative approach advanced by Lord Justice Underhill. In the absence of that argument and that substantive point, we say that the respondent's position on subsection A is not one that can be sensibly maintained. Before turning to B, I should also mention that you do have, as you heard from my learned friend, Potter and Lowe as well. I gave you that not just because it's shorter, and it is shorter, it sometimes contains convenient summaries of the principles, and we would in particular refer the court to paragraphs 4.59 to 4.64, which again I hope was consistent, indeed was consistent with the submissions which I made this morning.
Paragraphs 4.59.
459 to 464. And that deals with the issue of a presumption, when a presumption exists, and its strength and the relevant factors.
Thank you.
So it goes to that point. On subsection B, the case that's put forward by the Secretary of State really comes down to one of really surprise or impossibility, that we are seeking in our submissions to, as my learned friend put it, wash out our democracy to the world. My submissions do not go so far. This case, we say, is an example of one in which due regard, had it been given, would have been useful, ultimately for the reasons given by the judge. The focus is not on washing out our democracy to the world, but on what actions the relevant public authority, here, the Secretary of State, could have considered taking that might have had an effect on equality. Things that the Secretary of State here could have done in order to ameliorate the position. That is the type of due regard which we say should have been given consideration to those questions. That might have included things like giving consideration to an alternative means of referral, such as is available in other countries' schemes relating to refugees from Syria. How the needs of persons with a particular protected characteristic, here people who are Palestinian, or to put it another way, comparing it against people who are admitted who are not Palestinian, how their needs could have been addressed. That is not an impossible obligation. And we do say, and I do emphasise, that the concerns which have been raised are somewhat overblown in the context of a duty of due regard. And there is one further authority which is relevant on what due regard means in practice, and it's the Court of Appeal's decision in Bracking, which addresses this question, and it's in Authorities 3 at tab 39, electronic 1630. At paragraph 26 of the judgment of Lord Justice McComb, the learned judge sets out a list of propositions which he concludes can be derived from the authorities. It's important not to take these list of propositions as a statute, but it does helpfully summarise all of the previous case law, including on the question of due regard. Due regard is dealt with at subparagraph 8 on the right-hand side, and there's a quote from the judgment of Lord Justice Elias in Hurley and Moore. And if I could invite the court to read paragraph 78 of the extract from that judgment, gives a helpful summary of what due regard means in practice. We say, my
It's
lord,
quite difficult to be clear precisely what the equality implications are when you're applying this extraterritorially, isn't it?
what the equality implications are those equality implications which are apparent from the issue which arises. There will be many decisions which raise no obvious equality implications, and there will be some, such as this one, where the Secretary of State has been told repeatedly that there is a real problem, for example, for Palestinians in accessing a scheme that is on its face open to all nationalities, where there is such a concern. And where there is such a concern, that clearly in our submission comes within the concept of due regard. But this is not an obligation which, as that passage makes clear, requires the impossible. And it does not require something which a public authority cannot in practice, we say, achieve. And it's because of the limited nature of that duty of due regard that we say the difficulties which are put forward by my learned friend are ones which are, in our respectful submission, overstated. Unless I can assist the court further, those are my submissions in reply.
Thank you very much, Mr. Jaffe. Well, we're most grateful to all counsel for their assistance, and indeed those sitting behind who no doubt have played their part as well. We'll now consider the submissions that have been made, and we'll let you have our decision in due course.